the breach of duty of care, this is the second element under negligence. So the breach of duty of care is whereby the defendant has acted in a manner which a reasonable person can't act. So the breach of duty of care is what we actually refer to as carelessness or recklessness. So when you act in a careless manner or a reckless manner, we then say that you have breached legal duty of care. So a reasonable person, according to the law, is that person who is able to act on top of clampers or nimbus. Clampers or nimbus is whereby you are not able to act in overconfidence or apprehension. So if you are not able to act in overconfidence or apprehension, you are a reasonable person. So you are acting on top of clampers or nimbus. That is according to the law. So when you breach a duty of care, then you are acting in a manner which a reasonable person is not expected to act. Thus, you breach the legal duty of care. So there is a case of Blythe versus Birmingham Waters Company Limited. So the court defined negligence in the following words. Negligence is the omission to do something which a reasonable man, guided upon those considerations or circumstances which ordinarily regulates the conduct of human affairs, will do, or still doing something which a prudent or reasonable man will not do. So there are certain standards that courts establishes that a reasonable person should act, or if you act in a manner that is not according to those standards, then you are acting in a manner which is not of a reasonable person. So we say that there are three elements of negligence. There is legal duty of care, the breach of duty of care, and the damages. The legal duty of care, the breach of duty of care that results to damages. So the third element is damages. So the damages, under damages you need to establish that doctrine of Res Ipsa Loquitur. So the damages must be as a result of the defendant's actions. So if you are the plaintiff and you want to be awarded, and the case is not as issues or the facts of the case are not as a result of the defendant's action, the defendant is not liable of that issue, then you can't be awarded of the damages, because the omission to do a particular duty results in damages, and that damage must be as a result of the defendant's actions. So the omission to do, so the damages must be as a result of the defendant's actions. So you have this doctrine of Res Ipsa Loquitur, which says that facts need to speak for themselves. You need not to prove the facts must just speak for themselves. For example, in an accident where an accident has occurred, you need not to prove how this person was over speeding or if he was under drugs. The thing you need to prove as an applicant is that as a plaintiff or the counsel to the plaintiff side is that indeed the accident happened. If it's as a result of the drunkenness or overspeeding, that is not your business. You are just supposed to prove the accident happened, and the facts need to prove for themselves as a result of the actions of the defendant. So if you are walking and the building collapses and kills people are walking and the building collapses and kills people, those people need not to prove that the building was constructed under wrong circumstances, or the building collapsed because of maybe poor construction. That is not your business. Your business is to prove that indeed people died, and indeed people died as a result of the collapsing of the building. So other facts just need to prove or speak for themselves. So that is the doctrine of Res Ipsa Loquitur. So a case law there is the case of Municipal Corporation of Delhi versus Sabguati. The Municipal Corporation of Delhi, due to the collapse of the clock tower situated opposite to the town hall, the main bazaar, Chandni and Delhi, a number of persons died. The clock tower belonged to the Municipal Corporation of Delhi. So the tower belonged to the Municipal Corporation of Delhi, and the Supreme Court explained that the legal position as follows. They explained the legal position. There is a special obligation of the owners of the adjoining premises. Those owners were the ones who had the obligations. So that's according to this doctrine of Res Ipsa Loquitur. I hope you're understanding this doctrine. The facts need to speak for themselves. So these owners of this premise were the ones liable. So if you are to appear as a plaintiff side, you need not to prove that this building was constructed under wrong circumstances, or the contractors, or things to do, other things which are not necessary. You just need to prove the necessary factors if indeed people died as a result of that collapsing of the building. That's according to that doctrine of Res Ipsa Loquitur. Another case is of Wakelin versus London and Southwestern Railway Company. I don't know much about that case, but it's just about someone who died in a railway line, but I don't know a lot to do with that case. So it also establishes this doctrine of Res Ipsa Loquitur. So it has been an enjoyable lesson, I hope. So you can comment on the comment section on how to improve these online lectures, and you can also subscribe for those who have not subscribed. So you can comment there, so that on how to improve, so that we offer quality lessons. So thank you very much.